Major Supreme Court ruling.
Major ruling involving the Second Amendment.
The Supreme Court has just issued a major ruling.
It's a case that legal experts will be watching closely when it likely heads before the justices.
DOJ just swerved hard. Rolling into this week, I honestly thought the Department of Justice was about to cool it. After all the so-called pro-Second Amendment talk they've been floating, I figured they'd at least pump the brakes. Instead, they dropped a court filing so wild it made every gun owner I know freeze mid-scroll. Like, hold up, what did they just say? What's going on, folks? This is Tommy from Policy and Law Update, and today I'm breaking down exactly how Pam Bondi's DOJ just flipped the table on gun owners, and why this move hits way harder than most people realize. Before we dive in, do me a favor, smash that subscribe button, tap the bell, hit all the buttons down there. You don't have to, but it keeps this channel rolling and lets me keep bringing you this kind of real-world gun talk. All right, enough of that. Let's get back to it, because the DOJ just swerved hard. The promise versus reality. At the start of this year, every gun owner I talked to was hearing the same thing on repeat. Big wins were coming, national reciprocity was back on the table, constitutional carry expansion was being hyped. People were whispering that the NFA tax was finally about to get gutted. You had folks in D.C. talking about rolling back old regulations and putting the ATF on a tight leash. And a lot of us thought, okay, this might actually happen this time. Then Trump tags Pam Bondi to run the Department of Justice and sells it as the most pro-Second Amendment DOJ we've ever had. On paper, that sounds good. Really good. You've got the One Big Beautiful Bill Act signed on July 4th with a section that literally takes the NFA's $200 tax on things like short-barreled rifles, short-barreled shotguns, and suppressors, and drives it straight down to zero. In our world, that is not some cute footnote. The entire legal excuse for the National Firearms Act has always been, relax, it's just a tax. That logic traces back to a 1937 Supreme Court case. So when Congress kills the tax, everybody's thinking, no cap. The registry has to be on life support. But what we actually watched over the next few months was the exact opposite. The DOJ did not pull back. Instead of gearing up to stop defending old gun control laws, the DOJ kept showing up in court ready to protect the same NFA framework that Congress had just punched a hole through. That gap between what we were sold and what the DOJ actually did, that's where this story really starts. First red flag, the tax problem. Here's where the first real red flag popped for me with Bondi's DOJ. From day one, the legal excuse for the NFA has been simple. This is a tax measure, backed by that 1937 Supreme Court case that upheld the law under Congress's taxing power. Back then, a $200 tax on a short-barreled rifle or shotgun was serious money. That wasn't pocket change. Fast forward to this year. Congress passes the One Big Beautiful Bill and cuts those NFA taxes to zero. Not reduced, not adjusted, zero. If the entire foundation is, this is a tax, and the tax is gone, anyone paying attention is thinking, okay, this shouldn't stand the same way in court anymore. And that's exactly why a case like Silencer Shop Foundation versus ATF even exists. The second that tax got wiped, smart lawyers looked at the old Supreme Court logic and said, there's the weak point. Because when no tax is being collected, the registry stops looking like a revenue tool and starts looking like pure gun control. Congress said it out loud. Then you've got members of Congress sending the DOJ a letter, plain English, saying the intent was to deregulate these items by killing the tax and that the agency needs to respect that change. From a separation of powers standpoint, that's Congress telling the executive branch, we changed the law, adjust your enforcement. What made folks like me stop and say, damn, something's off here, was how the DOJ reacted. Instead of pausing, instead of recalibrating around the new tax reality, they walked into court acting like nothing had changed, like the old tax justification was still fully alive. That was the first clear sign they were more interested in preserving the NFA machine than respecting what Congress just did. The mask falls off. When that DOJ brief finally hit the docket, I sat down and read it cover to cover, and it didn't take long to see the game. This was not some neutral housekeeping filing. This was a full 48-page memo in Silencer Shop Foundation versus ATF asking the court to side with the ATF and keep the NFA structure intact as if nothing meaningful had changed. They attack standing. They claim the plaintiffs aren't really harmed. And they lean hard on the idea that the registry is still a valid use of federal power, even after Congress zeroed out the tax. You read it, and it's obvious. They walked in ready to defend the NFA, not rethink it, dismissing Congress. What really caught my attention was how they talked about Congress. Instead of treating the one big beautiful bill as a serious policy shift, the DOJ basically shrugs it off. They tell the judge that wiping the $200 tax doesn't matter because Congress still has general taxing and regulatory power. That's a big tell. They're trying to detach the NFA from the narrow 1937 tax logic that kept it alive and hook it into broader theories so it survives no matter what Congress does with the actual dollar amount. From a gun owner's perspective, that's dangerous thinking because it means future registries can be sold as tax tools and then kept alive even after the money side gets gutted. So when people call this a pro-Second Amendment DOJ, I point at that brief and say, read their own words. They are not acting like an agency that just had its authority clipped. They're acting like a department that thinks it can outlawyer the Supreme Court and the clear intent of Congress. That memo is where the mask really came off. DOJ's wild claims about guns. When I dug into how the DOJ talked about the guns themselves, that's where it got sketchy. They go out of their way to paint short-barreled rifles as easily concealable weapons, likely used for crime. Like owning an SBR automatically puts you in the suspect category. Short-barreled shotguns? They call them devastating tools at close range. Then they lump NFA items together as weapons of war. That doesn't sound like a pro-Second Amendment DOJ. That sounds like a gun control email blast. The issue isn't just the adjectives, it's the legal move behind them. They tell the court the whole point of the NFA is to target dangerous and easily concealable weapons. Sit with that for 5 seconds. A compact 9mm pistol is dangerous and easy to conceal. A braced pistol, a shockwave-style firearm, most modern home defense setups, all fit that label. That logic gives future courts a roadmap to bless bans on almost anything that isn't a full-size hunting rifle. That's why this filing matters. This isn't social media tone. This is the federal government handing judges language that treats our guns as contraband by default. The double talk. What really sealed it for me was the disconnect. In public, most pro-Second Amendment DOJ ever. In court, they're leaning on the Ninth Circuit to justify keeping a federal gun registry alive. The same Ninth Circuit that signed off on magazine bans and assault weapon bans. If you're serious about gun rights, that's not where you shop for arguments. They grab old cases that treated the NFA as a tax program and stretch them into a permanent permission slip. Their message to the court is basically, trust us, the power is still there. That's aggressive. The original 1937 logic was built around revenue. No revenue, no justification. Instead of admitting that, they double down. That's why I call it a betrayal. Because when it actually counts, in federal court, they're defending the same framework gun control states rely on. That's not an accident. That's a choice. Why this could still backfire? Here's where it turns interesting. Silencer Shop Foundation didn't roll in with a kitchen sink lawsuit. They built a clean, tight tax clause case. Congress dropped the NFA tax to zero, but left the registration requirement running. That collides head-on with the Supreme Court's own words. Right now, both sides are chasing summary judgment in the Northern District of Texas. This is about law, not messy facts. If the court agrees that a tax means actual tax, the registry takes a serious hit. And here's the thing. This DOJ brief proves they're not the pro-Second Amendment ally they claim to be. But it also shows exactly where they're exposed. If Silencer Shop wins here, other NFA challenges will tighten that blueprint fast. So yeah, I'm annoyed, but I'm also locked in, because one ruling here could change how the NFA operates faster than any speech in DC ever will. Before we wrap this up, I want to hear from you. Drop your thoughts in the comments. Do you think the DOJ crossed the line here? Or is this just business as usual in DC? If you're tracking this case, say it loud down below. And if this breakdown helped you see what's really going on, hit that like button. It tells the algorithm this matters and it helps this channel reach more gun owners who need to hear it. If you're new here, go ahead and subscribe. Turn on notifications so you don't miss the next update because this case is moving and we're staying on top of it. Appreciate every one of you. Stay sharp, stay informed, and I'll see you in the next one.